In an astounding move, the United Nations Commissioner for Human Rights moved the Supreme Court of India over the Citizenship Amendment Act. The UNHRC wants to be made a party into the existing pleas that have been filed against this law that has been passed by the Parliament of our country. And there are a bunch of these petitions, as you know, in Supreme Court. But the fact that United Nations now wants to interfere, well, that's unprecedented. India has been quick to react. India has in fact hit back, saying that Citizenship Amendment Act is an internal matter and it is the sovereign right of the Indian Parliament to make laws. No foreign party has any locus standi. Issues pertaining to India's sovereignty are our own, are internal, and it is clear that CAA is constitutionally valid. That's been the response from Ministry of External Affairs after United Nations moved the Supreme Court. The opposition has been quick to lap up this move. Adhir Ranjan Chaudhary of the Congress Party said, well, it's embarrassing for us. It's no more an internal matter now. But is United Nations right to interfere in India's internal matter? Is Citizenship Amendment Act really something where the UN should intervene and go to our courts? That's the big question. Harish Salve, top legal mind of our country, joins us this evening. Thank you, Mr. Salve. For me, this is really unprecedented. Can you remember any other time where United Nations has actually gone to the Supreme Court over a policy which is completely internal?
Not that my limited research has revealed any such thing. In fact, the US Supreme Court over the decades has invited what are called amicus briefs from interesting groups. And they have decided so many important cases of human rights, including segregation, racial rights, minority rights, and so on. I wonder how many times the UN rights body has considered it appropriate to try and dive in and advance their point of view. But I find this surprising on another level. The United Nations operates beyond municipal law. It operates at the level of countries. It operates where domestic law is not a defense for international treaty obligations. So if India violates the ICCPR, it's a matter of public international law to judge India's actions, and domestic law itself is never a defense. So for the UN's body to get involved in domestic law, its validity, its operation is very odd. I would not say it's unusual, it's odd. And the third is, we must always remember, we have not signed the optional protocol for dispute resolution because we maintain that while we have a commitment to civil and political rights, we are a sovereign country and we will decide our own issues. Our domestic law has sufficient remedies for remedying breach of human rights. Our Supreme Court has repeatedly relied on the ICCPR to construe the Indian Constitution and the rule of law. And therefore, for India, resolving constitutional issues, resolving human rights issues is purely a matter of domestic law. We have not agreed to the optional protocol by which the committee of the UNHCR would have had jurisdiction over India. Keeping all this in mind, I am more than surprised that this has happened. I would also say one thing: one may have strong views about the CAA, for or against it, but I think on one aspect we all are united. Whatever may be India's problems, our sovereignty is not negotiable. And if we do not accept international monitoring of what goes on, then we cannot accept this kind of intervention. If we allow and encourage this kind of intervention, today it is on CAA, tomorrow it will be on reservations, day after it will be on communal riots, and the day after it will be on drought and the measures taken by India. And are we going to allow foreign bodies to have a serious say in Indian courts and guide Indian policy? So I think we have to step back, and while the battle on the CAA has well been joined by those who are protagonists and those who are its antagonists. I don't think this kind of compromise of Indian sovereignty should be encouraged.
Yes, and on the other aspect, and you and I have had conversations about Citizenship Amendment Act, and we may not agree on all aspects of it, but I find it a little odd for the reason it seems as if the UNHRC hasn't understood the law properly, hasn't understood the issue properly. How can this be a human rights issue? We're not throwing anybody out of our country. We are simply saying that for few of them, the timeline would perhaps be different. Preference will be given. How is this a human rights issue to begin with?
Let me tell you where this is all heading up. India has refused to sign the Refugee Convention. Okay? The UN has tried through various agencies to put pressure on India to sign the Refugee Convention. We have steadfastly refused. This is the first step. Everybody has their own agenda. It's all very well for people to jump up with glee and say, oh, how good the UNHRC has jumped in and try and score brownie points over their fight with the government. But please remember, the UN has its own agenda. Are we trying to be pushed into a corner into finally accepting the Refugee Convention? Is that what we are going for? Because one of the criticisms of this law has been that why only from these three countries? Why not from other countries? Why not Rohingyas? Why not other Muslims prosecuted by their minorities, etc.? We are getting back into the area of the Refugees Convention.
So, Mr. Salvi, you believe that this is perhaps another way of forcing the government to perhaps agree to a larger international policy?
In fact, my answer to the criticism that why is this limited only to three countries was based on the argument that asylum, who should be allowed naturalization, is a matter of a country's internal policy. And if you allow it to people coming from other countries, and it's a matter of your internal policy. So this is the basic issue. It's all very well. Our Supreme Court will hear whether limiting it to people from minorities for three countries is good enough, and you should not throw it open to anybody who's a minority in his country. Our Supreme Court will hear and decide what our Constitution provides. But there is a larger agenda. I feel there is a larger agenda. And the larger agenda is to get India to open up on its refugee policy. There have been people who've been pressing for the refugee policy. There was a petition filed in the Supreme Court that India should accept Rohingyas, and the Supreme Court said nothing of the sort. It's for the government to decide.
Right. All right. So then my last question to you is this. Have we actually seen in recent times the UNHRC ask other countries and other governments to behave in a similar fashion?
Well, we haven't seen, but I hope if this is the new policy of the UNHRC, they will file interventions in the US Supreme Court also.
Yes.
And the US Supreme Court is deciding human rights issues.
Yes, Hari Salve, thank you so much for joining us this evening and taking the time out to help us understand what exactly is going on here. Thank you so much. Let's also say good evening to our panelists that's joining us this evening. Anila Singh, National Spokesperson for the BJP, Aryama Sundaram, Senior Advocate with Supreme Court. I've also got Mr. John Dayal, social activist, who's joining us right now. And the big question is, why interfere in a law that has been passed by our parliament, that is already under consideration by our Supreme Court? Is this really the jurisdiction of United Nations Human Rights Commission? Mr. Sundaram.
Well, I must say I'm very surprised. I was exceedingly surprised when I heard about this intervention application, because the reason for it is quite simple. The United Nations is a political organization. Whatever its many aims may be, whatever its charter may say, whatever its different wings do, basically it is a political organization. Now, being a political organization, I'm sure the United Nations, through whichever agency it functions, whether it's the human rights or anywhere else, can always bring about different resolutions as a body of nations agreeing or disagreeing with a certain country taking a given stand. Now, if a member country takes a given stand, the other member countries can always move for passing of resolutions, sanctions, whatever they want. These are different issues altogether. These are political issues. To say that you want to interfere within the municipal judicial forum of that particular country and say you want to be heard in the judicial forum in that country which is testing the constitutionality or otherwise of a certain action is, according to me, completely out of sync and is completely something which I do not believe the UNHRC should ever have done. According to me, the UNHRC can do anything they wish to assist the government of India to apply some kind of pressure on the government of India to have other countries try to do something if they feel that human rights are being violated. Now, that itself is a moot question. I, for one, do not believe that any human rights are being violated here, but that's a different issue altogether. But if they want to, they can do that. But I think for them to say, this is an Indian Supreme Court, it's a judicial forum, which is judicially deciding the constitutionality of, or otherwise, of a given statute, for the UNHRC to say, I want to be heard in this matter, and treat me like an amicus or otherwise, that's a ridiculous statement. Who is an amicus? An amicus is somebody the court looks to and says, will you please assist the court in our deciding this issue by finding some kind of background on it. Now, if that's for the court to decide, I've never heard of somebody applying to become an amicus, leave alone wanting to intervene in a matter where the UNHRC, I fail to see what role they could ever claim in a judicial proceeding. In other words, I would go so far as to say that they are intermeddlers. They are absolute intermeddlers in this.
Yeah, and I'm just wondering, what who could have possibly given them such bad advice? And while I have my own views on CAA, I find it odd that the plea that has been filed by the UNHRC actually goes on to show their own lack of understanding on this entire issue. And it says, examination of CAA in present cases raises important issues with respect to international human rights law and its application to migrants, including refugees. Special attention is to be given to core international human rights treaties to which India is a party. And I don't know which one of these treaties are we really not following by this law. But Mr. John Dayal, do you think this is right? Is this a place for the UN to interfere?
Oh, I wouldn't dare challenge the acumen of the two learned lawyers on the panel, especially the present one, for whom I have great respect. So I too am surprised the special rapporteur has intervened. But I want to make a few fundamental points. A, it is now for the Supreme Court to reject this plea out of hand. Government of India, to that extent, has no role in it. B, the very CAA debate, the statements of Prime Minister and Home Minister say that the CAA is brought about because human rights are being violated in neighboring countries and people want to flee, and possibly some of them want to come to India, particularly the Hindus. There already is a human rights issue and an international human rights issue. Third, I quite agree with everybody. India has always found the United Nations Special Rapporteur and the United Nations Human Rights Commission an anathema. Almost never but once has a visa been given to these two entities. The last one was, in fact, the Pakistani person, now dead, who was a special rapporteur, and she came in an international capacity and spent some time there. So it is not that. Lastly, if I may say so, India, most of all, is deeply concerned with human rights violations in other countries across the world. We intervene in small things, the turban issue in France, the shooting or police violence on people in New York, people of Indian origin, so on and so forth. We have time and again, and I'm not referring to the Bangladesh issue or 71, But I am referring to Sri Lanka, where India has gone to international fora and spoken of the internal affairs of other countries. And lastly, if I may say so, I don't agree that there are no human rights violations. I count every 4 years, I give up an application to the United Nations Human Rights Council on India's UPR, Universal Periodic Review, where I, together with many other human rights organizations, including the National Human Rights Commission, we give our opinion on where we think India has been deficient or faulty or in default of its concerns, its commitments to various issues of human rights, gender rights, forest rights, livelihood rights, housing rights, hunger issues.
No, that's fine. Fair enough, Mr. Dayal. And that's exactly the point, that you get to do that and many others get to, express their views, report the facts as they deem fit. And as a country, we have intervened, we've made statements, but we've spoken at the United Nations. We've never wanted, we've never asked United Nations to become a party to a legal case. Here is the United Nations going to our Supreme Court
I will not,
and challenging our law.
No, I will not. No, as a participant, I would not want to use I or we. I'll just use India. India, as I said, and I quite agree with the learned Mr. Aryama Sundaram. I mean, his evaluation, his surprise is my surprise. And this is, I think, it poses quite an interesting issue before the Supreme Court. Will they reject it out of hand? That opens up a whole other issue. If they accept, then it's opening up a Pandora's box. I don't think they will accept. I think this is just a fishing in stormy waters. I don't think this plea will go beyond the first step. But if it does, then, my dear friend, we have to answer a few questions. Anyway, the Vasudeva Kutumbakam, we are answerable not only to the family of a dead, to the community in India, but to the global community. That is how we give our forces to the international security apparatus to fight international issues in, say, Africa, for instance. That is how India wants to be on the Security Council, to have a larger say. Otherwise, we can reject the United Nations and say we are done with the damn thing.
Anila Singh, would you want to respond to what John Dayal is saying? That we often, speak our mind, take a stand, intervene in human rights issues across the world. Now, either we become part of UN fully or we just completely shut them out.
Look, I have absolutely no objection at all to the UNHRC or any other member country.
Mr. Sundaram, I will come to you in just a bit. I'll just get a response from the BJP representative.
Did you want my answer or were you?
Yes. No, I was asking Anila Singh. Yes.
Sorry. I'm sorry.
All right. See, Tanvi, just now two experts on your panel, Mr. Salve and Mr. Sundaram, they very rightly said and very rightly told rather that what is the role of UNHRC and is it a right stand or a wrong stand, and do they have any right to become a third party in CAA and file intervention in Supreme Court? So they told very clearly that they do not have any right, and Mr. Salve also mentioned this thing, that though India has allowed UNHCR to operate in our country since 1981, but we have not signed 1951 Refuge Status Convention or the 1967 Refugee Status Protocol. And yet this body, they are trying to intervene in our matter. MEA has very rightly and very aptly replied them that we strongly believe that no foreign party has any local standing on issues pertaining to India's sovereignty. India is clear that the CAA is constitutionally valid and complies with all requirements of its constitutional values. So this is the answer to UNHCR, but still if they want to go ahead, they can go ahead, and we have got confidence in our legal system, we have got confidence in Supreme Court. They are going to give them an apt reply that they should not try to project a precedent which has never ever happened in our country, and to to the best of my knowledge, in other countries as well, because we have not violated any human rights. I mean, if I can say something on the personal, from the personal point of view, just now Mr. John Dayal, he mentioned about Vasudhaiva Kutumbakam. Yes, because of this concept, we are still suffering the burns of this concept, Vasudhaiva Kutumbakam. We know it very well. So let our country operate. We are a sovereign country. We have got strong parliament. We have got strong judicial system. We very well know that what we have to do. Any law is not made like that. It has to be passed from the parliament, and parliament has representation from all political parties who represent people of our country. So I really fail to understand why UNHCR has to intervene, why they have to file this intervention. I really fail to understand what is the agenda behind. They should come clearly. Like India has always stood very strongly wherever the requirement is there, if we talk about the human rights. But it doesn't mean that we will start interfering in the matters of other countries. Every country has a system.
Okay.
And,
all right. Let me ask Mr. Sundaram that question. Mr. Sundaram wanted to make a point.
Everybody from...
And Mr. Sundaram, do you agree with what Harish Salve was saying earlier? Then perhaps this is a way of pressurizing India into agreeing to the other refugee treaty that internationally everybody is looking at.
Well, I wouldn't say I could go that far. There could be many motives for it, but I will take it at face value that the UNHRC or persons within the UNHRC believe that the CAA creates some kind of violation of human rights. Now, whether they are right or wrong in it is not the issue, but if they feel it so, there is a manner in which to proceed about it. The manner in which to proceed as the UNHRC is within their own charter, is to take action within the United Nations, is if they want to apply political pressure from other countries, other member countries, it is to appeal to the government of India to relook at it. Now, all this they can do. They can act within their charter, within their powers. They cannot interfere within the internal judicial system of India. The question before the Supreme Court is whether the CAA is constitutionally valid or not. The adjudicator for that, the final judge of that, is the Supreme Court. The Supreme Court will see whether it's constitutionally valid or not. Now, what does the UNHRC have to do to go before the Supreme Court of India and tell the Supreme Court of India how they feel the case should be adjudicated? The UNHRC are not parties, they're not necessary parties to be impleaded in this case. It's a different matter if the UNHRC believes that such an act is against human rights, it is against the Constitution of India, in which case they can start an intergovernmental, they can talk to the government, they can try to convince the government to change the law and give the reasons for that. And the government may accept it, may not accept it, may entertain them, may not entertain them. But this, I feel, is nothing but interference within the internal judicial system. And I'll tell you one very great anomaly. The anomaly in this is, let us assume for the sake of argument that they become a party in this litigation. If they become a party in this litigation and the Supreme Court is to say it is constitutionally valid, the CAA is constitutionally valid, and they as a party then become bound by this judgment. They are bound and they are a party to this judgment. Tomorrow, how can they thereafter agitate that it is not constitutionally valid, since they have asked the Supreme Court, please let us intervene in this case, make us a party in this case. And if they become a party in that case, what is the consequence if the Supreme Court decides? Does that judgment become binding on the UNHRC? Could the UNHRC say, sorry, we can't comment on this anymore because the Supreme Court of India has adjudicated in a case in which we were parties that it is constitutionally valid. We therefore cannot agitate this matter or take this matter up anymore. I mean, it is a ridiculous situation which will arise, and I don't know why such an application is being filed, especially by a wing of the United Nations, into the internal judicial domestic resolution solving process of a given country.
Yes.
This goes far beyond the charter, and I really can't see any justification for it.
Well, the more I listen to our experts, the more I am, completely amazed with this move, and I can only call it bizarre. Mr. John Dayal wanted to make a point. Go ahead, please.
No, I think we are not talking at cross purposes. We are all saying that we are surprised that this intervention, or at least this application, this writ, this plea, has been made in the Supreme Court, putting the onus now on the registry and the bench to see whether they reject it out of hand, whether they want to even listen to it, or whether they accept it and then say, as London Council just said, that creates a very fraught situation for the United Nations system, that they are bound by a ruling on a law which has been held legal by the Supreme Court, and which people like me across the country, human rights activists, say is not legal. And then we can't even go to the United Nations in the UPR and say this was thing, because the government will say, but the United Nations is agree with it. I quite agree that this has opened up a can of worms for everybody concerned, particularly for government. Now, how do they tackle it? Because, as I said, nobody wants to talk to me on that point. CAA is predicated on the premise that there are human rights violations in a neighborhood.
Yes.
It is indirectly by offering shelter. It is, if you look at it morally, it is not interfering, but intervening. I don't like the term interfering. Nobody interferes. You can be smacked on the wrist if you interfere. That would be almost like an act of war. But intervening, trying to persuade, is a good thing. I think India will not lose its luminescence if internationally it is proven that it works for the human rights of its citizens, as it's constitutionally guarantees, and occasionally governments violate. That was the point. You'll remember during the emergency, when George Fernandez and others were in jail, there were all sorts of, including Subramaniam Swamy, people going around the world asking for intervention, asking for investigation. Some of it was done, asking for all sorts of things. 40 years ago, maybe the international community wasn't so mature or whatever. They didn't do anything about it. And I think today, if the Supreme Court rejects it, we have a precedent. If it accepts it, which I don't think it will, but I hope it will, then we have a precedence in which we can expand the area of human rights. It is no harm to the government. It does not bring disrespect to the Supreme Court. It doesn't hurt our sovereignty one whit.
No, that I don't think it does, because I don't think our sovereignty is so vulnerable that it gets hurt by this move. But I just think it's completely unnecessary. And I'll tell you why I disagree with you, Mr. John Dayal. This is not an issue about our refugee policy. The Citizenship Amendment Act,
I know you disagree.
Doesn't talk about who is given refuge in our country. It actually talks about who, at what pace, in how much time, is made a citizen of our country. It's a country's decision on who should be given citizenship or not. Now, I may believe that our policy currently is discriminatory or not, but I don't think that this is a place for United Nations Human Rights Commissioner to come and intervene and go to the Supreme Court and say, well, this is violating human rights. I think there are a lot more, and you will agree, a lot more bigger concerning issues of human rights violation. For a minute, I would have even understood if this was about the NRC, where there is proof that the NRC in the state of Assam has gone haywire. And there may be problems with it when it was implemented there, and people may have ended up in jail when they shouldn't have been in jail. And if UNHRC wanted to raise that issue, I would have understood. I just don't understand how saying that certain people from countries will be given citizenship at a faster basis than others makes it a human rights issue where UNHRC has to intervene. That's all I'm saying. I'm completely out of time. I'm going to thank all of our panelists for joining us. We will have to wait and watch and see what the Supreme Court finally decides on this. So far, it's just a plea, an intervention plea that has been filed by the UNHRC, and the Indian government has made its stand very clear that this is no place for any foreign institution to interfere. This is our decision, this is our law, and our own courts will decide if it's constitutionally valid, if it is right or wrong. Thank you so much for joining us on this debate. Supreme Court appointed panel once again met the Shaheen Bagh protesters for another round of mediation. The panel submitted a report to the Supreme Court and have once again visited the protest site seeking a comprehensive solution to the protest. Those are the visuals from just a short while ago where we actually had Sanjay Hegde there, Sadhana Ramachandran addressing the people, one last time trying to convince them. Siddhant is actually joining me on the phone line with more details. Siddhant, what did the court-appointed panel have to say to the Shaheen Bagh protesters?
Well, yes, Tanvi, today's meeting was kind of an informal meeting with the protesters at Shaheen Bagh. So this was the first meeting post-Delhi riots. It was really significant. And today, mainly, both the interlocutors gave emphasis on Holi. So they have told the protesters that the protesters at Shaheen Bagh should send out love for the entire country before Holi, clearly hinting and asking them to come out with a solution before the Holi. And not just once, but more than 8 to 9 times Holi was mentioned before the protesters. They have also said that their formula, they can hand it over to the interlocutors in written. If they want to change the timing of the protest or the location of the protest, that will be conveyed to the Supreme Court. It was a very informal kind of a meeting for a very short time. They were there just for 20 minutes and then they left. And it was conveyed to them that now it is a time for them to show big heart and give gifts to the country before Holi gifts to the country. So this is what an emphasis was. So this big takeaway was that there could be a possibility that before Holi, some consensus can be drawn between the interlocutors and the protesters. Second, they have been asked to give it in written to the interlocutors so that it can be handed to the court. The new formula of protest. They again mentioned that we appreciate that when Delhi was burning, when riots were taking place, Shaheen Bagh was peaceful. This entire stretch was peaceful. They also appreciated this fact. So, all eyes are on Holi now. And they said that whenever they have the mutual opinion amongst themselves, they can call interlocutors again and convey to them. So all eyes are on Holi, and it's going to be very significant to see whether Shaheen Bagh protesters are going to accept this very last offer from the interlocutors of ending the protest or come out with a new formula of protest. Back to you. Back to this video.
All right, Siddhant. Thanks so much for bringing us that update.